Hello, my dear students. Today, in labor law first paper, we'll discuss the wages for layoff and retrenchment. As you all are aware that we are discussing the Industrial Disputes Act 1947, and under that head, we are talking about the wages for layoff period and for retrenchment. The topic is given unit number 4 of labor law first paper, and this is video lecture 35. And so far the layoff is concerned, the term layoff has been defined under section 2KKK of the Industrial Disputes Act 1947. Thus, layoff means the failure, refusal or inability of an employer on account of a shortage of coal, power or raw material, or the accumulation of stocks, or the breakdown of machinery, or any natural calamity, or for any other connected reason to give unemployment, to give employment to a workman whose name is borne on the must rolls for his industrial establishment and who has not been retrenched. Compensation for laid off period. A workman who is laid off is entitled to the compensation equivalent to the 50% of the total basic wages and DNS allowance for the period of layoff. If such layoff exceeds 45 days, the employer can either keep paying such layoff compensation or retrench the workers. So compensation for layoff period is equivalent to the 50% of the total basic wages and DNS allowance for the period of layoff. And if such layoff exceeds 45 days, then the employer can either keep paying such layoff compensation or retrench the workers. And Industrial Disputes Act 1947 is a special law which mandates payment of layoff compensation in the event of a natural calamity or other unconnected reason. This liability in this special law, which is specific, has restricted the payment of 50% of the wages, as I told you, as a compensation, which is limited to the first 45 days of the layoff. And as we have, though we have discussed in the previous lecture, but again, in brief, we would like to discuss that what are the essentials of the layoff. There must be the failure, refusal or inability on the part of the employer to give employment to a workman. The failure, refusal or inability should be on account of shortage of coal, power or raw material, or accumulation of stocks or breakdown of machinery, or natural calamity or any other connected reason. And the workman's name should be borne on the must rolls of the industrial establishment, and the workman should not have been retrenched. So these are the essentials of a layoff. And layoff is a measure to cope with the temporary inability of an employer to offer employment to a workman to keep the establishment as going concern. It results in immediate unemployment through temporary in nature. It does not put an end to the employer-employee relationship, nor does it involve any alteration in the conditions of service. Further, layoff occurs only in a continuing business. When the industrial establishment is closed permanently or its lockout is declared by the employer, the question of layoff has no relevance. So layoff occurs only in a continuing business, and layoff is justified only when it is in conformity with the definition given under section 2KKK of the Industrial Disputes Act. And the explanation given to this section further provides that if a worker whose name is borne on the must roll of the industrial establishment and who presents himself for work during normal working hours or working hours on and on any day, and he is not given employment within 2 hours of his so presenting himself, he is said to be laid off for that day. But if he is asked to present himself during the second half of the shift and is given employment, he is deemed to be laid off for half the day. However, if the workman is not given employment even after presenting himself at the commencement of the second half of the shift, he is deemed to have been laid off for the full day. I repeat, my dear students, that if the employee is being asked to present himself during the second half of the shift uh, and is given employment, he is deemed to be laid off for half the day. However, if the workman is not given employment even after presenting himself on the commencement of the second half of the shift, he is deemed to have been laid off for the full day. Further, Section 25A of the Act provides clearly that the provisions of the Industrial Disputes Act 1947 relating to layoff and retrenchment compensation do not apply to the following three types of industrial establishments. So what are those three industrial establishments which are excluded or where the provisions will not apply? An industrial establishment in which less than 50 workmen on an average per working day have been employed in the preceding calendar month. So on an average, less than 50 workmen on an average working day have been employed in the preceding calendar month. And B, industrial establishment which are of a seasonal character or in which work is performed only intermittently, there also provisions will not apply. And industrial establishment to which chapter 5th applies as inserted by the Industrial Disputes Act Amendment Act 1976, there also that will also fall under that establishment where the layoff and retrenchment compensation do not apply. So far the continuous service is concerned, the right to compensation under the Act occurs, I beg your pardon, the right to compensation under the Act accrues to a workman only if he has put in at least 1 year of continuous service. Section 25B defines what amounts to continuous service. A workman is said to be in continuous service if he is for that period in uninterrupted service. An interruption of on account of sickness, authorized leave, an accident, a strike which is not legal, a log, and a cessation of a work which is not due to the fault of the workman should not be taken into consideration for calculating the period of continuous service. Even if a workman has not been in continuous service for a period of 1 year, he shall be deemed to be in continuous service for the period of 1 year if he satisfied the following two conditions. So if follows satisfy these two conditions, then even if he has not completed 1 year of service, but he still will be treated as in a continuous service. First one is he was in employment for 12 calendar months preceding the date with reference to which calculation is to be made, and during such 12 months he actually worked for not less than 190 days in case of employment in the mine and 240 days in any other case. And according to the explanation of this section, for the purpose of calculating the number of days on which a workman has actually worked under an employer, the following days shall be included: the days on which he has been laid off under the agreement or standing orders or under this act or under any other law applicable to the industrial establishment. B, if the days on which he has been on earned leave will be included, and the days on which he has been absent due to temporary disablement due to accident arising out and in the course of his employment. And C, in case of a female worker, the days on which she has been on maternity leave not exceeding 12 weeks. And compensation of layoff rights of workmen according to Section 25C of the Industrial Disputes Act, a workman who is laid off is entitled to compensation equivalent to 50% of the total basic wages and dearness allowance for the period of layoff, as I have already told you. So this is the right of the workman for the compensation of layoff, and this right of compensation is, however, subject to the following conditions. He is not a badli worker or a casual worker. His name should be borne on the must rolls of the establishments. He should have completed not less than 1 year of continuous service under the employer. and the workman is entitled to layoff compensation at the rate equal to 50% of the total of the basic wage and dearness allowance for the period of his layoff except for weekly holidays which may intervene. And compensation can normally be claimed for not more than 45 days during any period of 12 months. So compensation can normally be claimed for not more than 45 days during any period of 12 months. And even if layoff exceeds 45 days during any period of 12 months, no compensation is required to be paid for the excess period if there is an agreement to that effect between the workman and the employer. And if the period of layoff exceeds 45 days, the employer has two alternatives before him. The alternative number one is to go on paying layoff compensation for such subsequent period, or he may retrench the workman. And the cases where the workman is entitled to receive the layoff compensation, provisions of Section 25E provides certain exceptions to the general rule for the payment of layoff compensation. In other words, even if the workman is laid off, he will be disentitled to claim compensation in his case falls within any of the three clauses of this section. So in these cases, workman will not be entitled to receive the layoff compensation. Number one, if the workman refuses to accept alternative employment, employer is offering the employment, but is refusing for that alternative employment, then workman will or the worker will not receive the compensation for layoff. If a laid off worker refuses to accept that alternative employment. But provided that employment has to be in the same establishment from which he has been laid off, or in any other establishment belonging to the same employer situated in the same town or the village within a radius of 5 miles from the establishment to which he belongs, or that alternative employment is, in the opinion of the employer, the alternative employment does not call for any special skills or the previous experience and can be done by the workman, and it carries the same wages which would normally have been paid to the workman in his original employment. So if all these conditions are satisfied and employer is offering an alternative employment and the workman is refusing, then workman will lose his entitlement to receive the layoff compensation. And absence from establishment, if the workman does not present himself at the appointed time during normal working hours at least once a day, then he would be losing this entitlement for the layoff compensation. And a strike and go slow tactic is there if such laying off is due to the strike or slowing down of the production on the part of the workman in another part of the establishment, then also will lose the layoff compensation. While effecting retrenchment of the workman, if it is obligatory on the part of the employer to pay retrenchment compensation at the rate of 15 days wages for every completed year, to be calculated at the last ground salary of an employee. I repeat, my dear students, while effecting retrenchment of the workman, it is obligatory on the part of the employer to pay the retrenchment compensation at the rate of 15 days wages for every completed year, to be calculated at the last ground salary of an employee. And there are certain condition precedent to the retrenchment under section 25F, that no workman employed in an industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by the workman until the workman has been given 1 month notice in writing indicating the reasons for retrenchment and the period of notice has been expired, or the workman has been paid in lieu of such notice. Wages for the period of the notice. B, if the workman has been paid at the time of the retrenchment compensation, which shall be equivalent to the 15 days average pay for every completed year of continuous service for any part thereof in excess of 6 months. So these are the condition precedent to the retrenchment of a workman. And C is the notice in the prescribed manner is to be served on the appropriate government or such authority as may be specified by the appropriate government by notification in the official gazette. And see, my dear students, apart from the retrenchment, means the payment for the retrenchment or the layoff compensation payment. Apart from these, because we all are just facing this pandemic time, so there are legal obligations to pay wages during lockdown also, and the directions issued by the government to employees to pay wages to all the workmen neither comes within the framework of the Disaster Management Act, and the Epidemic Disease Act, though we have, nor it is backed by any statutory law. And the government of India and the state government have called upon employers to pay wages for the lockdown period, not only to the permanent workmen of an industrial establishment, but also to contract workmen and interested migrant workers on humanitarian grounds. There can be two opinions about the need to pay wages to employees, and however, whether such an obligation should be that of private employers or that of the state needs to be considered. The central government, invoking the provisions of the Disaster Management Act of 2005, has declared a lockdown until 14 April, and the state government invoked the provision of Epidemic Disease Act 1897, have framed certain regulations, have issued certain direction, guidelines, communications, and the directions issued by the government to the employer to pay wages to all the workmen neither comes within the framework of the Disaster Management Act or with the Epidemic Disease Act 1897, or nor backed by any statutory law. But there are the Disaster Management Act provisions, if we talk, was enacted for setting up the National Disaster Management Authority and State Disaster Management Authority respectively, and to have unified command over disaster management. The powers of the National Executive Committee and the State Executive Committee have been listed in the Act. And a reading of the provisions of the Act would show that powers have not been vested with either the state or the central government to direct private employers to pay wages during a disaster, despite the employees not working. The scope of the Act empowers committees to frame plans to meet disasters. And further, we can see that the substantial part of this Act is Section 2 of this Epidemic Disease Act. And it only enables the government to prescribe measures to prevent the outbreak of such disease or the spread thereof. The same certainty does not clothe the government with the power to direct the private employer to pay the wages. These are the two enactments based on which the government have been issuing certain directions to the employers, given the provisions of both the acts and the language of the sections as analyzed above. There is no statutory provision to support the directions of the central or the state government with regard to the payment of wages. And in common law, an employer could lay off employees without payment of wages. To remedy such a situation, provisions are introduced in the Industrial Disputes Act for payment of compensation in the event of a layoff. The legislature in its wisdom introduced the term called layoff under the ID Act and mandated payment of compensation in certain circumstances and prohibited day layoff in certain circumstances. And irrational approach here is one that is further the direction issued by the government to pay full wages of bonanza to the employees, not merely because they earn it without having to work. The directions of the government have in fact resulted in the employees taking home more wages salary than they normally would earn. The example shown in the certain cases. And we can just go through the global examples also, considering the burden of the lockdown would have on industries. Government across the globe have taken measures to aid the employers. Like Denmark has announced that it will cover 75% of the wage bills. Canada has implemented a wage subsidy scheme. England has provided for 80% of the average earnings to be subsidized. Malaysia is providing a wage subsidy of. So it means we can see that the different countries across the globe are just going for the different policies so far the payment of the wages to the employees are concerned. My dear students, you can just go through these slides and then you will understand. And a way forward, the Indian government would need to come up with a scheme to subsidize employers towards the wages paid during the lockdown. And the scheme can be linked to profits earned by the industrial establishment and the wage bill for a month. In the absence of such a scheme, private employers, especially small and medium industries, will be put through hardship that could even bankrupt them. And the government, while drawing a stimulus or revival plan for the economy, should certainly consider subsidizing the wage cost for the lockdown period, if not in entirely, I beg your pardon, if not in entirety, at least in part. And if for any reason the government decides to extend the lockdown, it should be at the wage burden and should not give any advice for a payment of full wages given the tax authority to do so. So this is all about, my dear students. Means I have just give you a glimpse that how the government is directing, instructing, and how, in what way employers are going for the payment of the employees in this lockdown period. We have also gone through that the how the employees or the workmen will get the compensation under the layoff and the retrenchment. So this is all for today's lecture, my dear students. I hope that this lecture will definitely give you an insight about the wages for layoff and retrenchment. Thank you so much, my dear students, for your patience listening. And in our next lecture, we will take up some new topic in the Industrial Disputes Act 1947. Thank you so much. Have a nice time. Have a nice day. Bye-bye. Take care.